They upgraded both the search side of it and then also the application form side of it. So when they did that, they created a second way to fill out the new trademark forms. And the new form itself is kind of annoying for a practitioner. But the cool thing about it is that it automatically saves the information in the form. One of the biggest issues that the legacy system had is whenever the USPTO updated their website or their database, it would break all the application forms that had previously been sent out to clients.
Oh,
So, last December, I think we had, I'm assuming I probably had about 30 or 40 applications out there, all broken.
Anybody have an understanding of how to sell or commercialize a patent? I have a Canadian and a U.S. patent on my invention, which is in the oil drilling sector. It's been 3 years since it was granted, and I haven't done anything with it, trying to commercialize it and make it a reality. Yeah, I can imagine this is the type of invention where what has to do with like oil drilling, probably a high cost to make it, right? Engineer it and get this thing built. And so it's likely why you haven't, maybe it's a capital issue, haven't been able to raise enough funds to go bring it about. So in this case, licensing is a very viable option. The best way to go on this is to put together a valuation. And if you've got a third party that can help you do this, there are companies that can value your patent based on a market-based approach, even pre-revenue. So you can go have a discussion, create a sales sheet, if you will, and use a broker. Bold Patents offers a brokering service like this to go out and communicate on your behalf and share the valuation, share the marketability assessment, or what your invention covers. There's a second approach, which tends to be a bit more, I'd call it mean. It's a trolling effort where you can look for and spot infringers. So if you stay close, monitor the market in oil drilling, you might be able to find those that are kind of creeping up to or actually nearly infringing your patent. And you can then begin the conversation that way. There are ways to approach that by writing nice enough letters to let them know, hey, you might be getting close to infringing. I'd like to do business with you instead. How about we partner up and bring this to market in the right way? So those are kind of two thoughts from the patent side on how to commercialize in this area.
Yeah. Going to market's always hard, right? You need like subject matter expertise. So I always tell clients to put together some sort of board of advisors with people who have subject matter expertise in the field that you're trying to get into. And those folks are going to be probably your first investors anyway. So
yeah,
still duty for commercialization and capital raising.
Yeah, good deal. I'm rebranding my photography business, and this time I've decided that the trademarking the name is a must-do to copycat I had to deal with a few years ago.
Mm-hmm.
Potential catch: the trademark I'd like to register is also a URL that redirects to a painter's site. Their actual URL and business name is nothing like my business name. So it seems they're just covering their bases for SEO.
Yeah.
Have you seen this before, Matt?
Yeah. A lot of times clients will, preemptively buy up a bunch of domains, right? They might keep them. I don't know about you, but I have a few domains that I own that I'm not currently using, but I might at some point, right? So people kind of just collect these things. That's not a problem to have someone who owns the domain of the trademark that you want to use. So long as, of course, that domain doesn't redirect to a third-party site that competes with your services or products. Assuming you're not a painter, we're good.
Yeah. Okay, cool. So photographer with ABC123, they can likely register so long as the existing ABC123 URL doesn't forward to a competing photography business.
Correct. And more I think about it too, like let's say it was even a competitor who was using like a domain to redirect. Yeah. That domain isn't really functioning as a trademark, right? It's not a source indicator. It's just a URL. Yeah. So I would even make the argument that even if they were a competitor and they had that domain and they weren't using it, you could theoretically come in and file a trademark registration for it. Now you can't get that domain back from them. So you're going to be, in trouble from that perspective, but you could theoretically own it.
I have an Amazon listing back in November 2023 and applied for a patent in 2024. Question is, if I have a provisional patent application, my patent will protect me starting from the provisional patent application date. I didn't have a provisional patent, but I directly applied for a non-provisional patent. Let's say my patent application is approved. And let's say there is one product that infringes my patent rights. Okay. They listed it before, looks like. They're listing on a date between 26 November and 24 October. Okay, so they listed for about a year between 23 and 24. In this case, can my patent stop them legally from infringing competitors? Well, okay, couple of things to mention here. I want to make sure I clarify is that by virtue of filing a patent application, a provisional or even a non-provisional application, you don't have any rights. Okay, you have no ability to enforce your patents against others. However, you can send letters. You can send stern notice letters putting potential infringers on notice that, hey, you think this is infringing, articulating that, hey, when this does go to issue and you're still infringing, you're now a willful infringer, and you can threaten treble damages in litigation. I'll also say that Amazon, if you've got, the right patent grant, once it gets granted, Amazon will go to bat for you. And I don't have personal experience with this, but I know, Matt, you do on the trademark side. I assume it will work on the patent side as well. You assert, hey, I'm the registered owner. I've got this patent granted. Now they're going to have their own in-house, basically, tribunal is what they've set up. And so they're going to have, hopefully, attorneys, maybe they're non-attorneys, review your allegations, review the patent that's issued, maybe even look at the claims and assess on their own. They come up with their own determination about whether the article might be infringing or not. If they think it might be or it's close enough, they'll take down that other listing. And I think you're also asking about, basically, let's say it get issues now, previous or prior listings, right? So sales that were made while it was pending. That is a situation I may not have, I don't know the answer on that. Whether you be able to claim damages while it was still pending. I think there could be in federal court an avenue, so long as you put them on notice that you have pending right in 2024.
Very reasonable to me that you have a pending application, it's pending, you've given notice, right? Therefore, they should be responsible for their actions to me on that infringement.
Yeah.
Assuming the patent registers.
Does anyone know if there's a way to prepare a trademark form and save it for attorney review, either by sending it a link or sending an OBJ file? My account is not sponsored under an attorney as legal staff. The only type of form I can access is for an individual filing their own trademark. I cannot find any notices or information from the USPTO on how to use the new form by legal staff. Let me know if you have information or a link from the USPTO on how legal staff is supposed to do this. Does that ring a bell on
that? Yeah. So they're talking about like the legacy USPTO system and the changes that the USPTO has made in the last month. Okay. So the USPTO upgraded the website a bit. They upgraded both the search side of it and then also the application form side of it. So kind of your TTAB motion practice stuff and your application work filings, all that stuff has been upgraded. Okay. When they did that, they created a second way to fill out the new trademark forms. And the new form itself is kind of annoying for a practitioner. But the cool thing about it is that it automatically saves the information in the form. One of the biggest issues that the legacy system had is whenever the USPTO updated their website or their database, it would break all the application forms that had previously been sent out to clients. Oh, so last December, I think we had, I'm assuming I probably had about 30 or 40 applications out there, all broken, all had to be rebuilt, and it took weeks of work to get it back. I'm still working on that today, actually. I got a couple more. Huh. So anyways, the new system makes it much easier for attorneys to create applications for clients, update them, edit them, and then resend them if the client forgets to sign them in a good amount of time. So yes, you can still use the legacy system. That form is still available to you. You should be able to fill out that form for your attorney or your client and send it to them the traditional way still.
Okay. Got it.
I was just in that form earlier today. I don't believe you have to be even log into the USPTO account to do it anymore on the old form.
Got it. Thank you.
But best practice is to do what the USPTO wants you to do, which is register.
Yeah.
So I would find yourself a law firm who's willing to sponsor you or an attorney you can work for that can help you basically fill out these forms for clients.
Absolutely.